family. Give us your name and address for the record.
Good morning. My name is Jeff Kleinman, 1207 Southwest 6th Avenue, Portland 97204. I'm representing one of the neighbors, Lineal Vandermolen, who has the immediately adjacent farm property at 22262 Southwest Stafford Road. I prepared a somewhat lengthy memorandum, and I'll provide copies and leave them. There are several grounds for the opposition that we're presenting. Number one, we disagree with the staff report that the life estate and the split ownerships between the two spouses preserve the chain of title. We believe that's legally incorrect. It could possibly be that as to the split ownerships, each spouse would retain a Measure 37 claim as to half, but what's recommended in the staff report is incorrect. In this long memo that I'm sorry we were just able to complete yesterday and not get to ahead of time, we raised three issues. The first of them is that to grant a waiver under Measure 37 to allow residential development in a broadly EFU area brings back the doctrine of spot zoning, and that is absolutely unlawful. We haven't had that issue in Oregon for roughly 30 years since the Fasano decision in 1973, but it's back because of Measure 37. Second, because of the lack of transferability of the lots for development, the lots that would be created under the claim would be worthless. As a result, there's no reduction in fair market value under Measure 37. You don't gain anything by being able to divide but not sell or not build. So there's no reduction in fair market value, which is the threshold test. Next, most of this memorandum deals with the question of reduction in fair market value. What the claimant is asking for here is not its reduction or not their reduction in fair market value. What they're asking for is what's referred to as a monopoly value or an exception value. In other words, now everybody around them is restricted by exclusive farm use zoning. They want the value they would gain by being the only people in the area who are not restricted. This is far different from what Measure 37 contemplates, which is the situation at the time the regulation took effect, I believe in this case in 1979, the EFU zoning. At that time, everybody could do what they wanted. Now, the only folks who would be able to do what they want are the claimants, and that's not reduction in fair market value. Measure 37 and ORS 197. Can I take just about 30 seconds to wrap up? Measure 37 and ORS 197352, which incorporates it, deal with the topic of just compensation. That too is part of the threshold test. And if you look at that and you look at the language of the supporters of Measure 37 in the voters pamphlet, and we discussed this in this memo, there are allusions to just compensation and the law of eminent domain. Again, we discussed this at length in the memo. And if you look at the law of eminent domain, it compels you to look at the date the regulation took effect and the use was restricted in 1979. A proper measurement of reduction in fair market value under the statute or under the ballot measure would be the reduction that took place at the time in 1979, and you can add cost of living or some other rate of return on top of that. But that's really what the language compels, and not this monopoly value that people are asserting in these proceedings. At the time the regulation took effect, everybody and literally their grandmother knew what was coming down the road. The county did not drop EFU zoning out of the sky onto people's heads when they were sleeping. There was an extended process when the comprehensive plan was being adopted. These folks claim an ownership interest back to 1966. They knew what was going on. So what's the point? The point is that if the property had value for other than agricultural use, if it had value for development as claimed here, they would have done it in the years of notice they had that the restriction was coming. But they didn't do it because it didn't have value at that time for anything but the ag use. And as a result, there is no reduction in fair market value. The application does not address these issues. It only asserts, I believe, a 2005 valuation, which is just the inappropriate monopoly value that they're claiming here. Thank you.
Questions?
Thank you kindly.